Good morning. We are Group 2 and we will be presenting on the case study 2, Normala. Here is the table of contents and this is our group members. I'm William and I'll be presenting on summary of the case. This case is about Normala, a production operator in Negeri Sembilan who requested to start her maternity leave 1 week before delivery due to feeling unwell, supported by a doctor's advice. After she had her maternity leave, she was diagnosed with postpartum psychosis and given additional medical leave. Despite her medical condition, her employer terminated her employment. Normala and her husband claimed unfair dismissal as the termination occurred while she was still unwell and on certified medical leave.
Good day everyone, I'm Forcinia Johnson and today I will briefly explain question number 1 with reference to the Employment Act 1955. Identify the condition under which Normala is allowed to commence her maternity leave before her expected date of confinement, specifically under Section 37. Firstly, under Section 37, subsection 1, paragraph 8, subparagraph 1, female employee like Normala are entitled to 98 consecutive days of maternity leave for each confinement. Secondly, based on Section 37, subsection 1, paragraph B, Normala may begin her maternity leave up to 30 days before her expected confinement date. This gives her flexibility to rest and prepare in advance. Thirdly, under Section 37, paragraph B, if Normala wishes or needs to commence her maternity leave earlier than the 30-day period, she is allowed to do so if her condition requires it. Or, according to Section 37, subsection 3, this early commencement more than 30 days in advance must be supported by a medical certificate from a registered medical practitioner stating that she is unfit to work. Finally, as per Section 40, subsection 2, Normala is required to notify her employer within 60 days before her expected confinement of the date she intends to begin her leave. This ensures smooth planning for both the employee and employer. In summary, Normala can begin her maternity leave up to 30 days earlier by choice or more than 30 days early only with medical certification, provided that she informed her employer in time. That concludes my presentation. Thank you.
Next, question 2. Explain the maternity protection given to women under Employment Act 1955. Firstly, under Section 37, subsection 1, paragraph A, highlights the maternity leave entitlement where all the female employees are entitled to 98 consecutive days of maternity leave in respect of each confinement. Next, return to work guarantee under Section 37, subsection 1, paragraph AA, where after maternity leave, the employee has the right to return to her original job or a similar position with no loss of terms and conditions. Third one, maternity allowance or paid leave under Section 37, subsection 2, paragraph A and 38, where a female employee is entitled to maternity allowance for the full 98 days of their maternity leaves. Moving on, under Section 39, which is the payments of allowance to nominee on death of employee, where if a female employee dies during her maternity leave, her employer must pay the maternity allowance to the nominated person under Section 41, which will be discussed later on, or to her legal representative if no nominee exists. Furthermore, protection against termination during pregnancy before they had their maternity leave under Section 41A. An employer cannot terminate or give notice to a pregnant woman before maternity leave except for serious grounds under her own misconduct or business closure. To add on, protection of termination during maternity leave under Section 37, subsection 4. It is an offense to terminate an employee during her maternity leave unless the closure of the employer's business. On top of that, under Section 41, where it emphasizes the payment of allowance to nominee, a female employee may nominate someone to receive the maternity allowance on her behalf. Next, another protection is discussed under Section 42, subsection 1, which protection against termination after maternity leave for pregnancy-related illness absence. Under this section, employers also cannot terminate a female employee due to pregnancy-related illness for up to 90 days after the maternity leave ends with medical proof. Last but not least, termination before confinement with wages in lieu of notice under Section 42, subsection 2. If the employee is terminated with wages in lieu of notice within 4 months before confinement, she is still considered employed for maternity benefit calculations. Lastly, no forced waiver of maternity rights under Section 43, which highlights any contract clause that tries to make a woman give up her maternity rights, like leave or allowance, is automatically void and unenforceable.
Assalamualaikum, my name is Noraida Batrisha and I will be presenting question number 3. With reference to the Employment Act 1955, discuss whether Normala's employer has the right to terminate her services. Based on my analysis, Normala's employer had no legal right to terminate her, and I will be explaining why by referring to Section 41A and Section 42 of the Act. Let's now focus on Section 41A of the Employment Act 1955. This section clearly states that it is an offense for an employer to terminate a female employee who is pregnant or suffering from an illness related to pregnancy, unless it is due to misconduct, willful breach of contract, closure of the business. In Normala's case, she was pregnant. She had a pregnancy-related illness, which is postpartum psychosis. There was no misconduct. There was no breach of contract. The company was still operating. So, it is shown that under Section 41A, the employer had no valid reason to terminate her. In fact, doing so is considered an offense under the law. Section 41A Clause 2 is another important point. If a female employee is terminated while pregnant or ill from pregnancy, the burden of proof lies on the employer to show that the dismissal was not due to the pregnancy or illness. In Normala's case, the timing of the dismissal during her certified medical leave clearly links it to her pregnancy-related illness. Unless the employer can clearly prove otherwise, the law considers this an illegal dismissal. Now, let's look at Section 42 of the Act, which provides extended protection even after maternity leave. The law says if a female employee remains absent after maternity leave due to pregnancy-related illness, she cannot be terminated for 90 days after her maternity leave ends, as long as she is medically certified as unfit to work. Let's break down that with Normala's situation, she completed her 90-day maternity leave as required. She was then given an official medical certificate for postpartum psychosis. Her termination happened within this 90-day protection period. So under Section 42, her employer still had no legal right to terminate her. This protection exists because recovery from a childbirth can take time, and employees have a right to proper medical treatment without fear of losing their job. Based on Section 41A and Section 42 of the Act, Normala's employer had no legal right to terminate her service. The action taken was unfair, unreasonable, and illegal. Normala and her husband are legally justified in filing a claim for unfair dismissal, and she is entitled to compensation or reinstatement under Malaysian labor law.
My name is Lydia Napol and I will be presenting question 4, which asks us to identify the social security benefit available to Normala based on her case. The first benefit is the medical benefit under the invalidity scheme. Since Normala was diagnosed with postpartum psychosis, she may be eligible for free medical treatment at social panels, clinics, or government hospitals, but only if her condition is certified as serious and long-term. This benefit is covered under Section 37 of the Employee Social Security Act 1969 Act 4. The second benefit is the invalidity pension, also under the same Act. If Normala mental illness become permanent and prevent her from working, and if she is under 60 and have made sufficient contribution, she may qualify. According to Section 16 and 17, she must be certified as invalid by a social medical board and meet the contribution requirement, either a full or reduced qualifying period. Next, the third benefit is the job search allowance under the Employment Insurance System Act 2017 at 100. Since Normala was terminated from her job and her case doesn't fall under exclusion like resignation or misconduct, it qualifies as loss of employment under Section 30. If she has enough EIS contribution and register as a job seeker, her claim can be approved under Section 33, and she will receive monthly financial support under Section 34. The fourth benefit is the Re-employment Placement Program, also under the EIS Act. If Normala is later certified as fit to work, she may join this program for job placement, career counseling, and retraining. This is provided under Section 44 of the Act to help insured persons return to suitable employment. Finally, the fifth benefit is the Rehabilitation Benefit under Social Return to Work Program, stated in Section 57 of the Employee Social Security Act 1969. If Normala mental condition affect her ability to return to her old job, she may receive psychological or vocational rehabilitation to help her recover and reintegrate into the workforce. So, in summary, these 5 benefits together support Normala health, income, security, and reemployment journey as provided under social and EIS law.
This is the reference used for our case study. Thank you for listening.